So, very good evening, friends. Today we will be covering only one section, section 59, and the related case studies also, if time permits. I have already shared with you one PPT, which is covering the case studies also. But first of all, we'll go through the provisions as are contained in the code and then regulations, particularly the changes which are applicable for new syllabus, because questions might be set on those changes, and then to case studies if time permits. So, first things first, section 59. Section 59 is covered in chapter 5, which talks of voluntary liquidation of corporate persons. Now, there are two situations in which the company may be wound up on its own. One is as a consequence of default, so that is covered under section 10, whereby the company, the corporate applicant on behalf of the corporate debtor can make an application under section 10 if it has incurred a default amounting to 1 crore or more. In case of pre-pack also, an application can be made by the corporate debtor if the default is 10 lakhs or more. But here there is a concept of voluntary liquidation, which talks of a situation where there is no default. If there is a default, or if the company is unable to pay the debts, then it cannot go in for voluntary liquidation. So it is some sort of simplified exit scheme for those who do not owe any debt to anyone, or those who are able to pay the debts in full. So section 59 talks of voluntary liquidation of corporate persons, and it says a corporate person who intends to liquidate itself voluntarily and has not committed any default. So this is very important, has not committed any default. So if it is committed any default, then where it will come? It will come in section 10. May initiate voluntary liquidation proceeding. Yes, Srivasaluji.
Sir, just a small request, because I am not very aware about the company law. So
Okay.
what is the relevant provision for liquidation, voluntary liquidation in the company law, and how is it different from this? It's just a prelude, because we are going into detail. Before that, I just wanted to ask.
I'll be covering it side by side.
Okay, sir. Okay,
I'll be covering it side by side. I hope my screen is visible.
Yes, sir. It is visible. But the only point was whether there is a provision in the Companies Act also for voluntary liquidation.
Yeah. Actually, in the Companies Act, they say that, okay, what are the cases in which there are actually winding up provisions? So it says that a company may be wound up in the following circumstances. So two circumstances have been culled out from there, and they have been included now in IBC. Earlier, both these provisions regarding voluntary liquidation and inability to pay the debts, they were also contained in Companies Act. But now, those provisions relating to default, inability to pay the debts by the company, and voluntary liquidation, they have been withdrawn from the Companies Act. Now, if a company wants to voluntarily liquidate itself, it has to be done through section 59 only. No similar provision in Companies Act. Similarly, if there is any default, then also section 10 application has to be made through IBC. But there are other circumstances, like suppose the registrar feels that the company should be wound up, or the company is acting against the interest of the country, etc., etc. So those provisions are still contained in the Companies Act. So these two provisions, they have been withdrawn from the Companies Act by way of an amendment when IBC was implemented, and they have been brought here. I hope now it is clear.